Right now on Law and Crime Report. The death of Supreme Court Justice Ruth Bader Ginsburg has sent shockwaves throughout the United States and beyond. We revisit the justice's landmark cases. Plus, the city of Louisville has declared a state of emergency ahead of the impending decision in the police shooting of EMT Breonna Taylor. This comes as it has been made public that 6 Louisville officers are under internal investigation over Taylor's death.
I don't know what's happening. Somebody kicked in the door and shot my girlfriend.
And later, the charges against New England Patriots owner Robert Kraft are likely to be dropped. Last year, Kraft was charged with solicitation following a multi-county investigation of sexual activities taking place in massage parlors. This is the Law and Crime Report, diving into true crime and all legal stories making headlines in September 22nd, 2020. Good afternoon, I'm your host, Brian Buckmeyer, here at the Law and Crime Report. We begin our report by starting off with the passing of Justice Ruth Bader Ginsburg. For many, she was a trailblazer in many fashions. And whether you looked at her as a lawyer from the ACLU or her career as a justice, she was a trailblazer for that of gender equality, as well as the LGBTQ and other rights that she championed as both a lawyer and a justice. She passed away due to pancreatic cancer as she was fighting that for quite some time. At the age of 87, she took the bench in 1993 as an appointee of then President Clinton. Let's begin by bringing in our guests and talking about initial reactions. I'm joined with a good friend, Mike Korobanics, and I welcome Bernardo Villalona as a former prosecutor of 13 years in the homicide unit in Brooklyn, New York. I understand you're changing your profession. As we said earlier, you're coming to the dark side as a defense attorney. A stellar career. I applaud you both as someone who's practiced in that borough, who knows you on the show, and also your reputation. Welcome both.
Thank you, Brian.
Yeah, Bernardo, let's start with you. Just on Friday, we heard about the passing of Ruth Bader Ginsburg. It's an election year. It's a new justice position. Her reputation. There are so many things that are involved in this. What were some of your initial reactions about her passing?
Brian, I was in complete shock. Literally, I was sitting in my office and I had both of my computer screens up. And I got the message through Twitter that RBG passed away. And literally, I just froze for a couple minutes. Like, I couldn't believe what I was reading. And I was like, maybe it's fake news. But then I continued getting more notifications. And literally, I was just in utter shock. And I just began crying because I just knew what her death meant to the United States. I knew what it meant to the law. I knew what it meant to justice. And also because of the woman she is, the powerhouse that she was, and the significant change that she has made in our country. Let's just put it like this, Brian. I wouldn't be on Law and Crime right now if it weren't for her, just because of all the equality that she set forth in this country. And I will be forever grateful to her. Ruth Bader Ginsburg, she was literally the female version of Thurgood Marshall.
Yeah, exactly. She took many of the tactics that Thurgood Marshall used in the ACLU, championing different cases to further some of those rights. I mean, just a few off the top of the bat. Ruth Bader Ginsburg is really pivotal to things like obtaining a mortgage without the cosigner of a male, obtaining a checking account without the cosigner of a husband, getting a credit card without a cosigner of a male. A lot of the things that women do today that we just don't really question. We just think of them as normal. They didn't really happen until Ruth Bader Ginsburg took that mantle as both lawyer and judge. Mike Korobanics, what are some of your initial reactions as we get into, I mean, the elephant in the room is we have the election coming in the next couple of weeks. This is a major position in the judicial branch. What are some of your takeaways, either as her career or what we should be thinking about going forward for the Supreme Court?
Well, I think she was just such a stellar example. I always think of a quote I came across of hers when she was addressing law school students. She said, if you're going to be a lawyer and practice your profession, you have a skill very much like a plumber. But if you really want to be true to your profession, you need to think outside yourself and use your skill and profession to help those less fortunate than you. If that isn't inspirational to every lawyer to see how just with time, patience, and dedication and being true to yourself, you could achieve such great goals, not just for yourself, but for others. It's just inspirational, and I hope she's free from suffering and rest in peace.
Yeah. Let's listen to the late, great Ruth Bader Ginsburg in 1993 when she was being sworn in as a Supreme Court justice.
Justice Sandra Day O'Connor recently quoted Oklahoma Supreme Court Justice Jean Coyne, who was asked, "Do women judges decide cases differently by virtue of being women?" Justice Coyne replied that in her experience, a wise old man and a wise old woman reached the same conclusion.
So, Bernardo, you brought up Thurgood Marshall, and I think it's so apt that we hold Ruth Bader Ginsburg in the same voice, because Justice Scalia was actually the one, I think, who made that first analogy as to her profession and moving the needle in terms of equality. And it is true, because Thurgood Marshall was one of the first ones to take the Equal Protection Clause of the 14th Amendment and expand that beyond just a single group of people. When I realized that she had passed away, I was with my wife at the time, and we had this very real conversation about the fact that there are many of us in this country who can articulate a right that we have that was given to us by a Supreme Court case by someone like Ruth Bader Ginsburg, who fought for that. I wouldn't be able to marry the woman that I love today if it wasn't for a Supreme Court case. I wouldn't be able to be an attorney today. I wouldn't be more than 3/5 of a man. I wouldn't be free if it wasn't for Supreme Court cases. And so when you look at your life in the landscape of Supreme Court cases, and you look at a woman who championed so many of them to give to so many people, at least for me, I stood back and said, thank you. And hope that I, as a lowly public defender in Brooklyn, can take up even a fraction of what she did for my clients, and hope that we all, as whatever we are, lawyers, doctors, nurses, janitors, can pick up where she left off, and hopefully we can appoint someone to champion similar ideas, rights, and thoughts going forward. Bernard, I'll leave you with the final words as to Ruth Bader Ginsburg and your thoughts as well.
Well, I'll just have to say, I think about her decision with allowing women to be able to get a mortgage without needing to have a co-signer by a male or a husband. Because as I sit in my condo right now, I wouldn't have this condo, this place where I can sleep, a place where I can rest, if it weren't for that decision. So just to show at least one of the huge impacts in my personal life and in the lives of many. Ruth Bader Ginsburg, a daughter of Brooklyn, a woman of Brooklyn, the notorious RBG, will never be forgotten. She is a legend, and we will definitely be speaking about her generations after us and after us and after us, because she is a legend.
Actually, one more point as well, because, I mean, for many of us, 2020 has been really rough, tough, even more so for other people as well. But it's taken away so much, but also kind of showed us the struggles of others. Mike, she was diagnosed with cancer a while ago. This isn't something recent. She's been fighting this for quite some time, but she was still there on the forefront, attempting to be the judge that we know her to be. She was the second female judge on the bench. I think that the other women on the bench may say this as well, but without her, I don't think there would have been avenues for Sotomayor or Kagan to get there as well. She really opened the doors, and even you saw her there in '93 asking the question, do women judges come to similar decisions or in the similar way that male judges do? And I think she kind of took gender out of the equation and said, if you're a judge, you're a judge, you're a judge. It doesn't really matter your reproductive abilities. What are some of your thoughts as we listen to how she really fought through cancer through this all?
Well, Brian, it's very interesting you bring that up, because my wife accompanied me. I think it was 2 years ago. I got sworn in before the Supreme Court of the United States. and we were both so excited to be so close to Judge Ginsburg. Unfortunately, I think it was the day before we were already in Washington, D.C., when I think it was the first time, if I'm not correct, that she had missed a Supreme Court session, and unfortunately, it was the day I was getting sworn in, and it sort of took a little bit of that specialness out to just see that chair empty, and it's sad knowing that it's not going to be filled by her again.
Yeah. And I know this is me being an extreme legal nerd. It's what we used to do in law school when we really got a good decision, but I would encourage people to actually read some of her decisions, even her dissents, even though she wasn't on the winning side, because her words were often so powerful about what she hoped this country would be when it came to equal protection under the law, regardless of what or who you were. Don't just read the articles or don't even just listen to me. Dig a little deeper, and I think you're going to find out a lot more about this woman than what you're going to hear or see in the coming days. We're going to continue with more here at the Law and Crime Report right after this.
We know that that indictment is coming from the grand jury. We have faith that that indictment is coming from the grand jury. In addition to the Attorney General's office, we must remember that the FBI is also doing an investigation into whether there were criminal civil rights violations leading to and after Breonna Taylor's death. So we're going to be looking for the federal indictment to come from the Department of Justice as well. But it's important that people know that the city of Louisville, they're not the ones that can bring the charges. So today, what we did here was to do what we could do to bring a little bit of police reform, and it's just a start. But we finished the first mile in a marathon, and we got a lot more miles to go till we achieve and cross that finish line.
That was a family attorney for Breonna Taylor after that landmark settlement of $12 million paid out by the city of Louisville, Kentucky for the death of Breonna Taylor. As we said in earlier reportings, this was a huge amount by any standard. Previous to that, the highest paid out amount for an unarmed individual being shot and killed by the police was $8.5 million. For those of you in New York, to give some context, Eric Garner was given $5.9 million, so $12 million is large by any stretch of the imagination. However, now all eyes are focused on Louisville as the police department, from what we've been hearing, is telling officers they are not able to take vacation days or take off scheduled work days that have not already been authorized because they are anticipating a grand jury decision. Whether that's an indictment or a no true bill, we are not sure as yet, but it seems like Louisville is on edge and ready for either decision. Bernarda, talk to us about what we can be expecting and what we're hearing out of Louisville thus far.
So as you can see, Louisville is taking precautionary measures. So regardless of what the decision is by the grand jury, they want to try to keep the city and the people of Louisville safe, as well as law enforcement. So what's going on is that we know that the prosecution has presented a case to the grand jury. The grand jury is to decide whether there is sufficient evidence or probable cause to believe that these officers actually committed the crime that they are being charged with. Remember, grand jury is not a trial, it's not proof beyond a reasonable doubt. But what we do know is that if the grand jury decides not to indict, then the case goes no further. The case is over with on the state level. The federal level is they're still conducting their investigation, and that is completely separate. But what is unfortunate is that if there is a no true bill, meaning that the grand jurors decide that there's not sufficient evidence for these officers to face charges, is that the grand jury minutes are going to be sealed, meaning we will not know what evidence was presented to this grand jury. We will not know how the prosecutor presented the case, what way they tailored the case, or had the testimony put forth to the grand jury to try to bring about an indictment or not bring about an indictment. All of that will be sealed.
Yeah. And that's a great point, Bernarda, and that's par for the course. That's common across the country, grand juries are secretive. But let's add this little wrinkle to it, Mike Korobonics. We're also hearing an announcement that the 6 officers in conjunction with this case are being investigated. So as I hear, we're boarding up the federal buildings. Officers are not allowed to take time off during this time. But the officers are also being investigated. I don't know whether to make heads or tails of this. Do they know there's going to be no true bill and they're waiting for the storm, or are they prepared? Like, I don't know where to go with this. It's like I'm just waiting for it. Just tell me. What are some of your thoughts?
I have the same feeling and the same anxiety over this as you do. It's very unusual, in my experience, that you have an announcement that we're, building up security, we're bracing for this, because we know that grand juries are secretive. We don't know if they've reached a decision. I assume they have not, since they're still doing their investigation, but they may be coming near the end of presentation. I hope that this is not some fortune telling of what to prepare for, and I hope this is a neutral precautionary measure. But as you say, Brian, I don't know.
Yeah. And as Bernardo said, regardless of how this plays out, we're not going to see how the quote-unquote sausage is made, whether there's a true bill or not, because grand juries are secretive. We'll never see the light of day as to how that proceeding went. But of course, the Law and Crime Report and Law and Crime Trial Network has got you covered. When we hear it, we will bring it to you, and we'll obviously give you that expert legal analysis for it. Let's switch gears and talk about something else we're never going to see, and that comes out of the Robert Kraft case, because the prosecution has decided not to appeal the court's decision to go back and see whether or not that videotape, that alleged recording of Robert Kraft that is supposed to have shown illegal and illicit actions while he was getting a massage, they're not appealing that. In fact, the defense is going one step further and saying, if that's not going to be seen in court, we don't want it to see the light of day, and they're asking for that video to be destroyed. Let's take a quick look at the hearing, talking about the video during the defense's cross.
The body cam also picks up audio, correct?
Yes.
Okay. And for whatever reason, I'm asking you, do you recall saying it doesn't matter in response to that? I can make some up.
You said this, that I said that during the Robert Kraft traffic?
No. Right, this traffic stop right before that. The traffic stop right before that when your audio was on, before you ever knew you were going to stop, Mr. Kraft.
Okay. I truly, I'm sorry, I don't remember saying that.
Okay.
And I don't, if I said it, I wouldn't even know the context of how it was said, and obviously, and more of a joke with however you heard that.
Okay, so.
That was said.
Okay, so whether it was a joke or not, you don't have a
I don't have a recollection of it, so I'm not going to tell you that who I was talking to or whatever. I have zero recollection that I said that.
Right, but you're also not saying under oath, of course,
Well,
that you're
of course not,
100%
because you
sure.
probably have something that we're going to come back.
Wait a minute. The question was, do you recall? His answer is, no, he does not.
And then the final question is, while you may not specifically recall it, what you're not saying under oath is that there's no chance you said that, correct?
No, I wouldn't want to do that, because you may come back. I don't remember saying anything like that. If I said something like that tongue in cheek or in a goofy manner, which obviously looks terrible now, respectfully, I don't remember saying that.
I mean, so let's kind of piece this apart, because I think there's two really big issues here. Mike, let's start with you. You win the suppression hearing for your client. It's not coming in. Is it time to start popping bottles? Are we winning this trial? What are the next steps here?
I think in this case, we could start popping bottles, because I think other than the tape itself, based upon, sometimes the prosecution has to make value judgments on what we want to expend our resources and energy on, and is it a winnable case? Without a tape in this situation, I am sure it's going to be very difficult to get witnesses together, things of that nature. I think that the defense is in a very good position here.
Yeah. Let's take a listen to a little bit more of the hearing as, again, the defense argues suppression of this video that they eventually won.
I mentioned this morning, Judge, that and this is really just bringing to the court's attention as relevant precedent, that Martin County, just this morning, Judge in Martin County suppressed the video that was an issue in the Bridge Day Spa, which is the same spa that Inspector Herzog started, and that was related to this case. That Detective Fenton, we've heard a lot about. All of that warrant was suppressed today, Your Honor. I should say the video was suppressed. And the key reason, I'm not going to, you can obviously read the order yourself, but the key reason that the judge focuses on is the lack of proper minimization. In that case, Judge, and you can look at the warrant in that case compared to ours, and you'll remember the comparisons. That warrant was something like 29 pages. It had all kinds of undercover work. It had all kinds of other stuff that was going on. It was a much more elaborate warrant. And also it has minimization instructions in it.
All right, so Bernarda, it seems that they've got the suppression, and now the defense is looking like they want to go for the kill when it comes to this video, and they want it to be destroyed altogether, never to see the light of day, not just sealing and leaving it with the court records as a dismissed case. What do you make of this move by the defense?
Well, they definitely want to guarantee that this tape never sees the light of day. You just never know how another prosecution can open this case up and get that video. For example, as you well know, that in New York, you can bring in Molyneux evidence. So meaning that you can bring in evidence in a new case of a prior case, even whether you were charged or not charged in that case, or whether that video was suppressed in order to assist in the present prosecution of a case. So they want to prevent something like that from happening. They want to prevent from this video being accidentally leaked or taken out of evidence, because even though it's suppressed, this video will remain at the property clerk's office or wherever it is that evidence is stored, despite whether it was suppressed or not. It still remains in the building, so someone still will have access to that. You just never know what can happen in the future, because even when minutes are sealed, meaning that no one can get access to it, hey, look what happened with Bill Cosby. Remember, those minutes from when he testified in a civil deposition, those minutes were used against him in the criminal prosecution. There are just so many scenarios that can take place that you want to cut it at the very end to prevent anyone having access to it.
Yeah, I mean, Mike, Bernarda has given us the very well-articulated reason as to why this would be destroyed. And I agree with her, because we are all officers of the court that have the power of subpoena. Anything that is sealed can be unsealed, but anything that's destroyed cannot be undestroyed. Is this an intelligent play by the defense, or, as many are hypothesizing, is this Robert Kraft saying, I did something in that video I don't want no one to see, and maybe we should get rid of it? How are we supposed to interpret this?
Well, I think there's a third aspect to this, as we all know, is not many clients could afford to have that sort of evidence destroyed because they're worried about their public relations. Most of our clients are happy just to get out of trouble or from there under. So there is a whole new aspect to this. But my feeling is that no court is going to destroy this video. Regardless, it is the property of the state. They're the ones who took it, and they're the ones who are the prosecutors, and they don't know when it could become relevant again. And I don't think a judge is going to make such a final decision in that type of evidence.
Mike Korobonics talking about the inequities of the criminal justice system, where people with more money have greater rights than people with less. Mike, I feel like you've been hanging out too much with a public defender.
I started in Hudson County and Jersey City. I've been on both sides of it, so I've seen it.
But I do agree. I think, and also the major thing too is, you're a defense attorney. You've got to limit your client's exposure as best as possible, and you always advocate for their privacy, their rights, whether it be criminal or civil. This could just be a good lawyer, I think, in all regards. But of course, you've got to beg the question, what's in the video? I think many of us,
absolutely.
I think with the right, like CGI and right blurring, I think many of us would probably want to see this video to kind of really get down to the bottom. All right, so Bernarda doesn't want to see it.
No, I don't want to.
So maybe Mike and I will watch it with the proper, we'll blur out the parts, and then Bernarda will tell you about it so you can find out, because I think a lot of people are really curious about this and trying to get to the bottom of what happened, why are we going this route. But this is the way the Constitution works. To me, it seems that they casted a very broad and as a judge agreed, unconstitutional net, and they caught a really big fish here in that being Robert Kraft. But because of zealous and strong advocacy, we're never going to see this video. And as I think we all agree, unless someone wants to say otherwise, I think they're going to dismiss this case because there's not really much they can use to prosecute him. Anyone with any other thoughts?
But Brian, see, the prosecution, they can still go forward. But the way they can go forward is by granting immunity to the person that was performing this massage on Mr. Kraft. So that way, that person can testify as to what he or she did to Mr. Kraft and detail for us what was going on. But the prosecution will have to grant immunity to that person in order to proceed with a prosecution. But who's to say that a jury will be willing to convict Mr. Kraft on the word of someone that was also committing an illegal act on a person? So, you know, that's the other side to it. Exactly.
And if I recall correctly, I think that person who's accused of allegedly giving him a massage, there may be some immigration issues there as well. And when you couple that immunity might need to come from the feds rather than just the state. And as Mike said, and I agree with you wholeheartedly, Bernarda, that might be more than the prosecution really wants to bite off for this type of case. We'll see how that plays out. We're going to take a quick break and come back with more here on the Law and Crime Report. Welcome back. Rapper Bobby Shmurda was denied his parole board hearing after September 15th when he went before the board to discuss whether or not he'd be released a year early. If you recall, in 2014, he was sentenced to 7 years in jail. This would have been another opportunity for him to be released for parole. Oftentimes, individuals who are incarcerated for a length of time have the ability to go to the Board of Parole, especially in the state of New York, and request, based on the fact of their good conduct, or what we call here, good time already served, they can be released to the public, but monitored for the rest of that sentence. So what would have happened if September 15th, the parole board agreed, he would have been released, but would have had to come back and had appointments with parole, be monitored, and had his house or other establishments where he stayed inspected. However, what it appears to have happened is that because of infractions while incarcerated, the parole board denied his request. I think there are some allegations that his girlfriend attempted to smuggle a weapon into the corrections facility. He was reported to have a number of fights, and at some point in time, some drugs there. These would have been allegations that would have been used against him to deny that early release for parole. That means he will be scheduled to be released December of 2021. I am again joined with Bernarda Villalona, 16-year homicide prosecutor out of Brooklyn, New York, and Mike Korobonics. Let's talk about parole and Bobby Shmurda. We know him from his music and from some of this case. Bernarda, talk to us about what we have heard so far in this parole board meeting and what this means for him going forward.
Okay. So Bobby Shmurda, I am not surprised that he wasn't granted parole, because due to the violent nature of his conviction, remember, you know, he was charged with being in possession of firearms and other charges. But the parole board takes into account, one, the violent nature of your conviction. Two, are you accepting responsibility for what you were convicted of or what you pled guilty to? And three, what has been your history while you've been in custody? Have you been the model prisoner? And Bobby Shmurda has not been the model prisoner. So if you aren't able to behave or to carry yourself out in a following the rules type manner inside of a jail, then the parole board is not going to cut you a break in your sentence. And that's exactly what happened here. Due to the multiple infractions, I mean, one of the most severe is that you got a female to try to smuggle in a weapon inside of a jail, and you got caught on that. So why would this parole board grant you any kind of leniency and release you to the public when you're still committing these infractions while in custody? We also have to take a look at, I'm surprised that he wasn't charged in that case with the girlfriend bringing in the weapon, but I'm sure that the girl was actually charged. So we have to make sure that he doesn't pick up any other charges, because any other charges can lead to further time, further cases that he can compile and have to serve time on.
Yeah. Mike Carbonics, many people will know that there's no love lost between me and the Department of Corrections in the New York State. But if we're following what they're reporting, this makes sense. I understand that Alex Spiro, Bobby Shmurda's lawyer, is saying that he's extremely frustrated. It appears that many of the family and friends anticipated that he would be released a year early. But as we're hearing, and as Bernarda outlined, we've heard that there's been at least 10 violations or infractions, and that was probably one of the major reasons as to why his application was denied and why he will not be released on September 15th, as he was hoping, of this year, but instead December 11th of next year.
Well, like Bernarda pointed out, I mean, we've got to understand something here. They may have expected him to be released according to the parole tables, but you can only rely on the parole tables if you have a inmate who is following the rules and procedures and being a model prisoner. Evidently is not. And what's important to note is parole boards have an abundance of discretion in their decision. It's not like a criminal case where it's proof beyond a reasonable doubt. It's basically a bare minimum of due process where they could do an investigation and basically find by a preponderance of the evidence these violations. So, this does send a message out to those who are incarcerated when he comes back after that hearing to his cell and tells them why he wasn't released and the reasons. That sends a stronger message out than when a court sentences, in my opinion, because here you are with all these people who are in your same situation and seeing that it may not be worth the risk, no matter how smart you think you are. They don't need a heavy burden of proof to deny you parole.
Yeah. Now, Bernarda, Bobby Shmurda is saying that the system is pitted against him. He's quoted as saying, we look guilty in these orange jumpsuits, and saying that if you put Al Sharpton in an orange jumpsuit and accuse him of having a gun, he's going to be guilty in these orange jumpsuits. He's saying that for the most part, the officers had lied and put a gun in his hand that was never there. He explained it to his record label, Epic, and they were behind him all the way. He's saying that he had big money lawyers and they still couldn't do nothing because of the judge. They looked at him as a black thug, and that was the reason that he was incarcerated on the initial charge. He's making claims that he was pushed into taking this plea and saying that the precipice or the beginning of this all, well, really he's having fault with. I know he said this through multiple lawyers. I think you and I, we won't name any names, I think you and I know some of his former lawyers as well and how he went through the system. What are some of your reactions as to his thoughts as to how he was treated leading up to this conviction or this plea?
So, Brian, I guess my thoughts would be different if he would have took it to trial and was found guilty. But Bobby Shmurda took a plea where he had to admit that he was guilty. He had to admit to the allegations. So with you admitting to it, and it's sworn testimony where a person, a stenographer, actually typed down everything you said, the words coming out of your mouth is, yes, I did this. So no one forced you to say that. I could understand if you're saying, oh, I blew trial and I was found guilty, but I wasn't guilty. The evidence was just stacked against me and the jury didn't understand. No, you took it upon yourself and you accepted the plea and you knowingly and intelligently entered that plea, understanding the ramifications. So it's very difficult when it's coming out of your mouth that, yes, I did this, compared to what you're saying now, that you were forced to take it or that you're presumed guilty because you're in an orange jumpsuit. No, you took it upon yourself. You took this plea and you accepted the jail time that was offered to you. You could have taken it to trial and could have fought it, but you didn't.
Let's switch gears ever so slightly and let's bring up Britney Spears. There are more issues with her conservatorship where the judge is looking to appoint a co-conservatorship in that her father, Jamie, is asking that another individual be added to that. Now, Britney Spears is saying that she does not want a co-conservatorship. She is pointing to the fact of both finances as well as the fact that she does not want this individual specifically to be a co-conservator, that being Andrew Wallet. He was appointed as a co-conservator of her estate some time ago, back from 2018 to March of 2019. Some of what she's saying is that he was too expensive, that he required her, not directly, but indirectly, to continue to perform in order to cover some of the costs associated with him being a co-conservator. And so that is one of the many arguments that she's putting forward as to why she does not want this to happen. She, of course, wants the court to relinquish more power from that of her father, Jamie, and of course not give it to this Wallet gentleman and give it to her, but that's what we're going through right now. Mike Korobonics, what are some of your initial thoughts as we're talking about this co-conservatorship and how it should be balanced out based on the request of Britney Spears?
Well, they're very difficult and they're very intricate anytime you have a court appointing someone to handle someone else's finances. I can imagine it's very frustrating for Britney Spears, but I think this is a type of matter that is very document and accounting sensitive, interest of all parties.
Yeah, and Bernard, a similar question. We're hearing that this request is actually coming from Jamie Spears, the father of Britney Spears, to add on another. This doesn't seem to be a request from a judge or from Britney Spears herself. And of course, Britney Spears is not really wanting this. Some of the allegations that Britney Spears is saying on her attorney is saying on behalf of her is that this decision was made an hour before the hearing, suggesting that this is kind of just being pushed along without any real thought or consideration. What are some of your thoughts about this?
Well, it seems to me, well, one, Britney is having issues, obviously making decisions for herself. That's why there is a need for there to be the father or this other person to assist in managing her affairs. But I think Britney is right in the sense that she is not requesting for this additional person to be added. You add an additional person, that means additional money. So what is going on with the father that's not allowing him to handle all the affairs just on himself? I think maybe we've gotten to the point where Britney really has to get a completely different and neutral third party to handle her finances because there's too many issues going on within the family.
Yeah, and Britney Spears would agree with you, Bernarda, because she actually filed a competing petition to appoint Bessemer Trust Company of California as a conservator of her estate, a request that her mother, Lynn Spears, also supports. So now we're having this competing. Britney wants this impartial third party to be the conservator. The father is wanting this other individual, Andrew Wallet, who was a conservator in the past. Mike, I know this is reading tea leaves, but it seems that so far the reports have been moving towards her getting more autonomy. It doesn't seem to make sense that we would be having two instead of one. And if the one is asking for a second, maybe there's a reason for it. Maybe we should just go to an impartial third party altogether to make this streamlined and easier. I mean, it would seem easier instead of having co-conservatorships. Just yes or no, what are your thoughts on that?
Well, it's just interesting that there's a conservator who's appointed who's basically saying, I can't handle it. So you would think they would have the best interest of Britney because that's why you appoint a conservator, is to do things in the best interest. I don't see how making additional fees from her money can help her.
Yeah.
So I think she has a valid point.
Yeah, we'll see how this plays out for Britney Spears as she fights through this dilemma. We'll continue back more here at the Law and Crime Report after this break.
We had people over last night. We were drinking. Most of us went to bed. One of them stayed on the balcony. She was drinking, and we just went outside, and she's laying face down in the backyard. It looks like, I'm guessing maybe she fell off the balcony, but she's stiff.
Okay, is she breathing?
I don't know if she's face down.
That was the 911 call after a mother of five, Tamala Horsford, was found dead, face forward on the ground where she's suspected of falling off of a balcony. Now, she was at a slumber party with a number of women and some men. The reason why the slumber party, we believe, started is because many of them shared children who played on a Pee Wee football team. Now, this was an opportunity for them to let their hair down, so to speak, have a couple of drinks, but it ended tragically with the death of a mother. Now, no charges were pressed, but many people who are following this case kind of have a lot of questions that don't seem to be able to be answered because of a botched investigation. This started off as a case of an accident. No witnesses were questioned. No one really asked where they were or what happened. But now, some months later, the circumstances are becoming more and more peculiar, and people are asking more and more questions. An investigation has been prompted based on the story getting more and more notoriety. Again, we're ending off our segment today, but let's have Bernarda and Mike give us a little bit more of that expert legal analysis. Mike Kourovanix, I know you're big into investigations. I've heard you talk about cases, and an investigation is the bedrock of any case, regardless of if you're a defense attorney, prosecutor, or somewhere in between. I don't know if we're going to get answers in this case because of a lack of a proper investigation. What are some of your thoughts when you heard about this case and going forward?
Well, we showed a picture before, Brian. So there's, 6, 7 people sitting there. For this investigation to even move an inch to say they even had any good faith attempt, I would expect to see 7 statements from those potential witnesses. If there aren't 7 statements, the only reason there shouldn't be a statement from one of those potential witnesses in a fundamentally fair investigation would be that someone said, I am asserting my Fifth Amendment right. It appears here that this investigation has a lot of questions to answer. And one of them, besides the statements, is how does a wrist become dislocated? Usually that's a defensive type of injury where someone is pulling away from someone trying to take a grasp at them. There's a lot of questions here, and this needs a thorough investigation, and I would start on that couch.
Yeah, and Bernarda, let's actually dive into those injuries, because many people are taking the injuries and saying this doesn't make sense. One, how do the people know, if they're all asleep, that she fell from the balcony? 2, if she did fall from the balcony, why are we seeing injuries, as Mike was alluding to her head, neck, torso, a fractured second vertebra, a laceration to the heart, injuries to her eyelid, and to the bridge of her nose? As Mike was saying, some of these injuries don't really coincide with falling from a balcony, and many are saying that this fall, and we probably got to eventually get Joseph Scott Morgan in on this one, that this fall would not be the type of fall that result in death in this nature. So we're left with more questions and answers, and many people are furious about this. What are some of your thoughts?
So I agree, Brian. I don't believe that the injuries actually reflect the story that was being told, that she accidentally fell over the banister, especially since no one actually saw that or said that they actually saw that. So they're making assumptions because she is found on the ground. So the sad part about this, Brian, is that the only way you're going to get answers is by speaking to everyone that was present at this slumber party. But if you think that there's some kind of foul play by one or all of the people that were present during the slumber party, then again, they don't have to talk to you. They can assert their Fifth Amendment right not to actually speak to you. So you're caught in the crosshairs. It's like you don't know whether to give someone immunity, if that person's going to agree, if I give you immunity to actually speak against the other people, what they may or may have not done. So it's very dicey in order to get answers in this investigation, what you need to do and what you have to decide. But it's going to be difficult unless you actually start giving immunity to people that were there if you do expect that there was foul play. But based on the injuries alone, I believe that there was some kind of foul play here. But again, just the injuries, that's not going to get you an indictment or a prosecution. You need some type of evidence.
Exactly. And to throw more fuel into the fire, one of the individuals on the 911 call, Barrero, is a former pretrial service officer, and he can be heard on the 911 call. He was he was actually fired for accessing the police file in this case. So a lot more questions are coming up than answers. Bernardo, Mike, thank you for being here with me today. Make sure to check out Law and Crime Trial Network for a regularly scheduled program after this. We'll see you all tomorrow. Have a good day.